Arkansas has one of the least regulated tenant screening environments in the entire country, consistent with the state's overall minimalist approach to landlord-tenant regulation. As we've discussed in our other Arkansas videos, Arkansas is one of only a few states that has not adopted a version of the Uniform Residential Landlord and Tenant Act, and the landlord-tenant relationship is governed by a combination of Arkansas Code Title 18, Chapter 17, common law principles, and the lease agreement. This light statutory framework extends to the screening process. There are virtually no state-level restrictions on how landlords screen and select tenants. Let's start with application fees. Arkansas does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. Arkansas's limited landlord-tenant statutes do not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable. Most Arkansas landlords charge between $15 and $35 per applicant, on the lower end of the national range, reflecting the state's affordable rental market. Excessive fees can discourage qualified applicants in a market where many tenants have limited financial resources, so keeping fees proportionate to actual screening costs is practical. Criminal history screening in Arkansas is completely unrestricted at the state level. Arkansas does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to look-back period limits. No Arkansas municipality has enacted local criminal history screening restrictions for housing. Little Rock, Fayetteville, Fort Smith, Springdale, Jonesboro, and every other Arkansas community operate under the same completely unrestricted framework. The screening environment for criminal history is entirely uniform across the state. Arkansas has provisions for sealing certain criminal records under Arkansas Code Section 16-901401 and following. The state expanded sealing eligibility in recent years, allowing more offenses to be sealed after specified waiting periods. Once a record is sealed under Arkansas law, it should not appear on a standard criminal background check, and landlords cannot consider sealed records in screening decisions. Screening providers should filter sealed records from reports. Arkansas has also enacted provisions for the sealing of non-conviction records, including dismissed charges, acquittals, and nolle prosequi dispositions. These records should be filtered from screening reports. Arkansas has not legalized recreational marijuana. Possession remains a criminal offense, though medical marijuana is legal under a 2016 constitutional amendment. Landlords can consider marijuana possession records in screening, but should be aware that the state's medical marijuana program means some applicants may have legal authorization for marijuana use. HUD's 2016 guidance on criminal history and disparate impact applies in Arkansas. Arkansas has a significant African American population, approximately 16% of the state's total population, concentrated in Little Rock, Pine Bluff, the Delta region, and other areas. Criminal history policies that disproportionately affect Black applicants face scrutiny under federal fair housing law. While Arkansas's legal culture is generally favorable to landlord rights, the federal framework governs. Documenting your criteria and applying them consistently protects you regardless of the state's permissive environment. Arkansas's unique criminal eviction provision, which allows tenants who fail to vacate after proper notice to be charged with a criminal misdemeanor, has no direct impact on the screening process. But the existence of criminal penalties in the landlord-tenant framework reflects the state's overall property rights orientation and the broad discretion given to landlords. Source of income protection does not exist at the state level in Arkansas. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No Arkansas municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. Arkansas has relatively high poverty rates, and a meaningful portion of the rental population receives government assistance. While excluding voucher holders is legally permissible, the market reality in many Arkansas communities is that government-assisted tenants represent a significant portion of the available applicant pool. Many Arkansas landlords find that voucher tenants provide reliable rent. The housing authority pays its portion directly and on time. For credit reports, Arkansas follows standard FCRA requirements: permissible purpose, written consent, and adverse action notice procedures. Arkansas does not impose any additional state-level requirements for credit report access, adverse action content, or notification timelines beyond the federal baseline. One practical consideration for credit screening in Arkansas: the state has lower average incomes and higher poverty rates than the national average. Credit scores across the state's population tend to be lower than national norms, not necessarily because applicants are poor risks, but because the economic conditions broadly affect credit profiles. Setting credit score thresholds calibrated to Arkansas's local market conditions rather than national standards ensures you don't exclude otherwise reliable applicants. A credit score that would raise concerns in a prosperous suburb may be entirely typical for a stable, employed tenant in Arkansas. Arkansas's fair housing protections are found in the Arkansas Civil Rights Act, Arkansas Code Title 16, Chapter 123. The act prohibits discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status, mirroring the Federal Fair Housing Act. Arkansas has not added additional protected categories such as sexual orientation, gender identity, marital status, age, ancestry, or source of income beyond the federal baseline. The Arkansas Fair Housing Commission, operating under the Arkansas Human Rights Commission, investigates fair housing complaints. While the state law mirrors federal protections, recent federal interpretations of sex discrimination may extend some protections based on sexual orientation and gender identity. Arkansas landlords should be aware that this area of law continues to evolve at the federal level. Arkansas does not have a comprehensive state fair housing enforcement infrastructure comparable to more heavily regulated states. The Arkansas Fair Housing Commission investigates complaints, but with more limited resources than agencies in larger states. Federal enforcement through HUD and the Department of Justice fills gaps in state-level enforcement. Tenants who believe they've been subjected to discriminatory screening can file complaints with either the State Commission or HUD. From a practical standpoint, Arkansas has a diverse rental market with dramatically different dynamics between its growth corridor in the Northwest and the rest of the state. Northwest Arkansas, the Fayetteville, Springdale, Rogers, and Bentonville corridor, has by far the strongest rental market in the state. The region's explosive growth has been driven by Walmart's world headquarters in Bentonville, Tyson Foods in Springdale, J.B. Hunt Transport in Lowell, the University of Arkansas in Fayetteville, and a rapidly growing technology, healthcare, and cultural sector. The Crystal Bridges Museum of American Art and the broader Walton family investments have transformed the region into a nationally recognized destination. Northwest Arkansas's rental market is tight with strong demand and rents that are significantly higher than the rest of the state. The applicant pool includes corporate employees, vendor representatives, university students and staff, entrepreneurs, and a diverse immigrant workforce, including a large Hispanic and Marshallese population drawn by the meatpacking and poultry processing industries. Screening in Northwest Arkansas involves a wide range of applicant profiles. Corporate relocators from across the country may have excellent credit and income, but no Arkansas rental history. University students have limited credit files. Poultry processing workers may have limited U.S. credit history and non-traditional documentation. Having documented criteria that can fairly evaluate each of these applicant types is essential. Fayetteville, home to the University of Arkansas, has a tight student-driven market supplemented by the broader NWA economy. Screening students with limited credit and rental history requires consistent cosigner or guarantor policies. Little Rock, the state capital and largest city, has a moderate and diverse rental market. The economy is driven by state government, healthcare, including the University of Arkansas for Medical Sciences, and multiple hospital systems, logistics, financial services, including Dillard's and Stevens Inc., and the legal profession. Little Rock's rental market varies by neighborhood. The Heights, Hillcrest, and Riverdale command premium rents, while other parts of the metro are more affordable. Little Rock has a diverse population, approximately 42% African American, and criminal history screening criteria must be carefully documented and consistently applied. Disparate impact risk is real in a city with this demographic composition. Documented, uniform screening criteria are essential. Little Rock Air Force Base near Jacksonville generates military rental demand. Military tenants provide reliable and verifiable income, and landlords should understand military income documentation, leave and earning statements, and BAH rates. Fort Smith, on the Oklahoma border, has a moderate and affordable market influenced by manufacturing, healthcare, and the University of Arkansas at Fort Smith. The market is stable but offers limited pricing power. Jonesboro, home to Arkansas State University, has a student-influenced market supplemented by healthcare and regional commerce. Pine Bluff has one of the most challenging rental markets in the state. Significant population decline, high poverty rates, and limited economic opportunity constrain demand. Landlords in Pine Bluff face the challenge of finding qualified tenants in a shrinking applicant pool. Hot Springs has a moderate market driven by tourism, healthcare, and retirement migration. Texarkana, straddling the Arkansas-Texas border, has a market influenced by both states' economies. The Delta region of eastern Arkansas has the softest rental markets in the state. Population decline, limited economic opportunity, and high poverty rates constrain demand. Communities like Helena, West Helena, Forest City, and West Memphis have limited rental activity and small applicant pools. Setting realistic screening standards in these communities is essential. Criteria appropriate for Northwest Arkansas would exclude virtually every applicant in the Delta. The poultry processing industry, concentrated in Northwest Arkansas and parts of Western Arkansas, employs a large immigrant workforce that represents a significant portion of the rental market in some communities. These workers need affordable housing, and landlords serving this demographic should have clear criteria for evaluating processing industry income, typically hourly with variable overtime. Employer verification of current employment and average hours provides the best picture of ongoing income. One best practice for Arkansas landlords. Because the state has essentially no screening regulation beyond federal law, your written screening policy is your most important compliance tool. Document your criteria: credit score threshold, income to rent ratio, rental history requirements, criminal history evaluation standards, and how you handle applicants with limited credit files. Apply those criteria to every applicant uniformly without exception. In the absence of state regulation, your documented criteria and evidence of consistent application are your defense if a screening decision is ever challenged under federal fair housing law. Another best practice: calibrate your screening criteria to the specific Arkansas market where your property is located. Northwest Arkansas, Little Rock, and the Delta have fundamentally different economic conditions and applicant pools. Criteria that work in Bentonville may be unrealistically strict for Pine Bluff. Set standards that identify genuinely high-risk applicants while remaining realistic for your specific market. A third best practice: for landlords in communities with significant immigrant and poultry processing worker populations, develop clear criteria for evaluating applicants with limited U.S. credit history. These applicants may have no credit file, no U.S. rental references, and income from hourly employment. Rather than automatically rejecting these applicants, establish alternative evaluation methods, accepting cosigners, verifying employment stability, using bank statements to demonstrate consistent income, and apply them consistently. This workforce represents a growing and essential part of Arkansas's economy, and having documented criteria for evaluating non-traditional applicants is both fair and practical. Arkansas does not have a comprehensive statutory framework for security deposit returns, comparable to most states. The rules regarding deposits are governed primarily by the lease terms and common law principles. Without a specific statutory return timeline or cap, landlords should include clear language in the lease addressing deposit amounts, return timelines, and deduction procedures. The lack of statutory guidance makes the lease itself your governing document for deposits, and makes thorough screening all the more important since your deposit protections are only as strong as your lease. For the complete guide to Arkansas tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.